Hi, my name is Melissa Gragg, and I'm a financial mediator. I am part of the Divorce Allies as well as the owner of valuationmediation.com. I'm here today because I have been working to help couples settle their divorces from a financial aspect for the past 20 years. I testify in court for business valuations and other financial matters, not only in divorce, but partner disputes and other litigation matters. And what we've noticed in the divorce space is that there is a lot of power in a settlement offer. And a settlement offer sometimes takes place, further on down in the divorce than at the very beginning. And the reality is, if we really, really look at things, the financial disclosure is the first thing we need to file for divorce. And that could be called something else in each state, but your state is going to be your first resource to find free information, to find legal help, to find the downloadable documents and forms that you'll need to fill out. And quite frankly, if you hire an attorney, they're going to also provide you with those forms to fill out. Initially, one of those forms is a financial disclosure, and it goes through all of your property statement or your statement of income and expenses. And what that means is you're going to pull together a lot of financial documents in order to file for divorce. And what we're saying is if you're going to pull together those financial documents, why don't you get a little bit more prepared and produce a settlement offer? And quite frankly, a mediator could work with you to come up with what that offer or disclosure looks like. So if you work together, you can come up with a financial disclosure where you'll work through the values, you'll work through all of your assets, you'll kind of discuss each of the pieces one at a time. And that's how a mediator could really be helpful in this situation, because we see that mediation is most effective when it is an overtime process. So that means that you're meeting once every week or once every other week, and you're addressing the issues that are really relevant at the time. Recently, we had a couple that the most pressing issue was the child custody and how to deal with everything throughout the holidays. So that could be the starting point for the mediation, or working together to come up with a settlement disclosure that you can submit to the court, and the court then can approve and you guys could be divorced. So what we've created is a concept called a settlement offer. And I'm going to walk you through some of the concepts to this settlement offer. And settlement is a play on words. So it's the phonetic spelling of what a settlement offer is. And quite frankly, the purpose of dispute resolution or alternative dispute resolution, which is mediation, arbitration, and even collaborative divorce. The goal is to get you to a point where you are either agreeing to the values and all of the assets, and then also agreeing to how they're going to be split up. If you can't agree to some of these issues, then that's when you would go into the court system and you would try to get the judge to tell you how to split the assets. Typically, that is an avenue that if the judge is determining your assets, then you're actually having somebody else outside your family determine what's best for your family. So that's also kind of taking your chances at what that particular judge in that particular county, which is the county that you live in and you're going to file in, that random judge is going to have the best decision for your family. So the only way to kind of backtrack out of that situation is to take matters into your own hands and either work together for a settlement disclosure, or even on one side, you can start to do some of your own research, pull together a lot of your financial documents, and put together a settlement offer that maybe you provide to them in an email or give to them when you go to mediation. Sometimes in divorce, if you have child issues or custody issues, your state could mandate mediation before you see the judge. So this is an opportunity that if you don't have a lot of access to either the financial records or the financial accounts, you can use mediation information to start to gather that data. It's kind of a discovery process, which means you're requesting information, you're asking for certain documents or financial statements. It could be a recent bank statement, it could be the past 3 years of bank statements. And so each of you are going to have this obligation to provide this information to each other. And what we work forward and work through is creating that financial disclosure, which is basically the amounts that you're putting forth into this situation of the divorce. And you're saying, here's what we have, here's what I have access to. And then you also need to provide the documents that you have access to. So initially, when we're even talking about a settlement offer or how to create this financial disclosure and negotiate a settlement offer, it's basically like we've said already, the financial disclosure is typically one of the forms that you're going to fill out to get divorced. Why is it a financial disclosure? Well, you're basically, when you got married, you legally came together, but you didn't quite put together like an operating agreement or a shareholder agreement or a partnership agreement that stipulated and determined how you were going to split up. That could have been a prenuptial agreement or a postnuptial agreement, and those would be important agreements to let your mediator know about if they are available or applicable in your situation. But for the most part, each state is going to require you to put together a list of your assets and debts, property, houses, cars, things like that, what the value is, and then also who's going to keep that particular asset or debt. And if you're going to split it, are there any quadros or other legal arrangements that then tell what happens? So a lot of times what we're doing is creating a financial disclosure that then leads into like a divorce decree or a divorce document that would say what you're doing with everything, not only your financial arrangements, but your arrangements with the children, your arrangements with the house or selling or keeping property. So what we've seen is that if you're going to already put together the financial disclosure, and a lot of times this is a disclosure that you're actually hiring an attorney to do. Now, the reason why this gets complicated is you're hiring an attorney to file a financial disclosure. And so they're really just going to say, hey, could you fill out this form? And for the most part, the forms, even when you download them from the state, they will just have these numbers. Like you will just say, list your house, list the value, and list whether you're keeping or not. Now, the other side is also going to have to provide that information as a response or another financial disclosure. So if you start this process, we really think the most efficient way to go about it is to first come up with that settlement offer. It's basically the same information that you're going to put together on your disclosure, but you're talking to your spouse before you file. And this means that maybe you can come up with an agreement to some of the issues and then hire a mediator to work you through the rest of the issues. Like I said, typically you're going to have financial issues. You're going to have issues related with custody of the children. You could have issues related with custody of pets. You could have secondary houses or other types of assets that are being allowed to be used by the other person for some period of time. So again, what's the difference between a financial disclosure and a settlement disclosure or our proprietary process? Really not much. So that's the issue, is that if you're already going to pay somebody to put together the financial disclosure, this is something that you could actually start to do on your own. You just need a standard template to work through and start to pull together those financial documents. At the point that you get to certain areas like the value of the house or the value of a business, you're going to have to call in other professionals anyway. But you might be able to get further on down the process if you don't have some of these complicated issues. So why start at the offer? Quite frankly, even if you don't have access to any of the accounts or any money, you could start to put together, based on this Excel template, which we'll go through in probably 10 or 15 minutes. And it's very easy to start to put together the pieces of the puzzle. So you kind of have to look at the assets and debts or your property statement as a whole bunch of pieces to a puzzle that you're kind of putting together in a full picture. So it's okay if you don't have all the pieces, because part of the process is if the other side has some of the pieces, that they also have to disclose those pieces and those property items or accounts, and then provide some of the backup data. And it could be that you guys are providing each other with 12 or 24 months of data, just to kind of prove what each person has spent their own individual money on or the joint money. So, how do you mediate the couple through the offer together? Well, quite frankly, what we do a lot of the time is work with the couple together. And it's most effective and most efficient because you're both coming to the table and you're being truthful about the things that you have. You also need to be truthful about the things that you want to keep or the things that you want to give up. So sometimes if neither party wants to keep the house and it's going to be sold, then that clearly will not necessarily need an appraiser to put a value on it. You're going to need a realtor to provide a price, and you're going to need to kind of get ready for market. So that means maybe agreeing upon the amount that you need to fix up the house, agreeing upon when it's going to be put on the market and how it's going to be put on the market, and each person's contribution to that. Then when the property's sold, you split the money in some predetermined way based on all the other assets. So mediating a couple through this process is really everybody's coming once a week or once every other week to move this process forward. Typically, we can see that you can get through the process within 6 months, but that's going to require that you're meeting every other week in order to get through some of these major issues. The first mediation could really just be to talk about the background of the issues, to establish some of the values to some of the easy pieces of property, and to talk about the kids and living arrangements. Typically, this is the biggest issue of who's going to stay in the house and who's going to depart the house. Or if you have to sell it, who's going to have to live in the house while it's getting ready for market. So what do you need to even mediate the financial picture? A lot of times we're starting with simple spreadsheets, and sometimes people don't understand the numbers. But if you start with like a simple document request, first of all, just understanding what is the date that is relevant to your divorce. So a lot of times everybody's moving towards the date of divorce, which is like your actual trial date, which continues to move in the future. So if that's the case, you're kind of constantly updating these settlement offers. So more often when you can update it as of a recent date and then start negotiating based on that, or even splitting some of the assets when you've determined that you could split them, that's going to be important. If the date of valuation for your state is the date of separation, then that could be understanding, do you guys agree to that date of separation, and then determining all the values based on that date. That's a little bit better process because then you're not constantly updating that form. You're all looking at the same date. You're providing all the documents as of that date and then prior to that date for everybody to review. And then you're moving forward with one settlement offer as of a date. That's a lot simpler process, but there's other states that constantly move the needle towards trial because you're still married and you're not splitting your assets until you're really getting divorced. Sometimes there's even a shore up right when we get to trial. So this is going to be important to first start with those documents. And so if you're going into mediation, quite frankly, coming up with a settlement offer before you get there, even if you're not working together, is going to be your best bet. And putting it together in a very concise format is going to help everybody understand what your intentions are, what the things that you want to keep, and where are some of your non-negotiables. And so if you start to upload these documents, one way to work together is that all of you would upload documents to one single portal. And so that means that if I upload my bank statements, they go into the portal. That means both the couple, both parties get to see the documents. If they had attorneys, those attorneys could also see the documents. And if there was a mediator, the mediator could look at the documents. A lot of times we're working with other mediators or financial professionals that are putting together your full offer, but they need a piece like the valuation, a pension valuation. And so they're coming to us as an expert. But quite frankly, we also work together with the couple, and that is, again, a very efficient process. But in that, typically the communication needs to be very specific. So a lot of times couples are having a little bit of trust issues, and they need to make sure that the mediator is sitting in the middle and not necessarily on one side or the other. When we're talking about a valuation, we're actually providing a value, and that is us not really sitting in the middle. It's us being on the side of the company and saying that we are really presenting what the company's documentation or the company's financial picture looks like. And we're providing that to the couple, eventually maybe to their attorneys, and eventually maybe to a mediator. But if we're working in the middle, we make sure that emails to all parties are communicated very transparently. So what does that mean? Somebody sends us an email and we respond, making sure that everybody is included. And there's also typically no separate meetings or communications until the end. So what does that mean? Well, we have a process that we're working through, and specifically in the valuation, we might have some individual meetings, but they're not going to be until we've really gone through the process of negotiating the full global offer. And then we may have some private conversations with the attorney and the spouse, but that's only to clarify their specific issues and to give them a basis of understanding of what a reasonable range of value would be. And a lot of times when we're negotiating, we really need to start understanding what a reasonable range of value is for any of these pieces of property. So like even a house, you can look at your house and you can say, okay, this is worth $225,000. Or is it really somewhere between 200 and 250? So if you can start to come up with reasonable ranges and both of you create reasonable ranges, then you're going to have a better idea of how to put these different pieces in the financial settlement offer. So some of the things that you might have to deal with as you go through the settlement offer is mental wellness during the process. And so if you're the mediator and you're sitting and working with couples, then you have to understand that they're going to have different mental capabilities and emotions during this process. So when we're meeting every other week or every week, it allows us to move as quickly or as slowly as possible. It allows everybody to work through the mental states of really anger and emotions and frustration that are natural with the divorce process, and they don't necessarily stall the entire process. And so we kind of move through and talk about the things that are most relevant to the parties in that particular week and understand that this is a little bit of a marathon. And so that you can't just have it be done very quickly. Mentally, not everybody is always capable of getting divorced that quickly. So even a 3 to 6 month process is going to be enough time. The state of California requires a 6-month cooling off period before you can even finalize your divorce. So it could be that the state even prevents you from moving forward in a super duper capacity, which means that you might just need to file and then finish with an attorney. But these are the types of difficult issues that if you are mediating or going through a mediation, you need to be aware of. So a lot of times when we get to the appraisal of the house, like we can work through a lot of these issues, but if we get to the house and we don't agree on the value or both people want to keep it, then it might be a good idea to get an appraiser or talk to a realtor that can give you a value. And again, if you're working together, it may be that you talk to one or two people, each of you suggests somebody, and then you pick somebody that is reasonable and kind of a third party not related to you. So you could also look at a business valuation. And so a lot of times people just want to agree to what the values are for the house or the business. But if it's a highly contested issue, and with the house, it depends on if one of the people are going to keep it. So if one of the people are going to keep it, then you probably want to get an appraisal so that you know what that value is. But if you're going to sell it, it's going to be split, or in some capacity, the value is what you can receive from it after maybe you put some effort and pay some realtors to sell it, right? So you're going to have a net equity that is after the sale of that asset. Now, in the business valuation, typically one person is going to keep that business. And the person that is keeping the business would probably want that business to be valued at a low amount. And the person that is not keeping the business would want the business to be valued at a high amount. So a lot of times in the business valuation, we're really looking at it as an independent issue, other than the fact that one of the things is that the business is sometimes also the income to one of the people, one of the spouses. And so in that particular situation, you're dealing with something called the double dip. And you just have to be mindful of it and understand it, but we won't go into too much detail right now. Some of the other issues that we have to be mindful of is separate assets, or if anybody can prove those separate assets. If there is an inheritance, or that inheritance has been used to buy an asset, to put a down payment on a house, to buy any other assets that the person believes is still their separate asset. There could be communications around the gifts, or the wedding rings and other types of jewelry. If any cars or bigger objects have been gifted or provided for birthdays, there could also be a discussion about that. Typically, when we're getting into, we have kind of the mental issues, the financial issues, and then we have the children issues. And so when we're talking about custody, we're pretty much putting together a parenting plan. And the parenting plan is going to dictate, when are you exchanging the children? When is your visitation? How are you going to communicate and co-parent in the future? How are you going to participate in holidays or vacations? And where, a lot of times we're asking people, like, what's important to you? Because sometimes Christmas is important to one person, or Hanukkah to another, and then Thanksgiving to yet another. So again, you're kind of being mindful. Sometimes spring break and fall break are also important things for the children. So this custody, or how you're going to be splitting the nights with the children, come into play with child custody or the child support number. And so the child support number is typically a calculation based on your state and a couple other legal factors. So when you get to custody or alimony, child support and alimony calculations, sometimes alimony is called maintenance. Those are going to be areas that have a legal issue as well as a financial issue. So a lot of times attorneys or mediators can calculate what the child support would be or the alimony, but that's typically based on a summary of your tax returns. So if your tax returns are not reliable, then we may have to look at your bank statements or other ways of determining your income. So in those cases, it could mean that you need an expert to provide you with some information, but an attorney or a mediator could also provide it. There's also resources and softwares out there that provide you with a calculation that could be helpful. If you're having a CPA or financial planner put together a number, they should be trained to know divorce and not just provide you with a number based on their financial software. So one of the things that we recommend if you go through our settlement process or you put together your own settlement offer is you might need to figure out how you file for your divorce and how you finish the divorce. And so the settlement offer kind of sits in the middle. So a lot of times what we're saying is if you come up with a settlement offer, you could actually start to talk to your spouse about that offer. You could, if it's difficult to talk to your spouse about that offer, you could engage a mediator to come in and help you put together the offer, put together the settlement disclosure, use their own spreadsheets to help you put that together in a reasonable fashion. Sometimes it's spreadsheets, sometimes it's a Word document. Any way that you guys can really clearly get an idea of what you have and what you're willing to keep and make sure that everybody is on the same page is going to be the best. So you can decide at some point. So let's say you put together the settlement offer. Now that's the same information, and maybe you don't agree on everything, right? You can use the mediator to go through some of those disagreements, or at some point you can determine that you're just going to need to go to court to determine like one or two issues. You can settle 98% of your case and still go to trial for one or two issues that are just very gray areas. Maybe both of you believe you have a good position on that issue. Like you believe that that's a separate asset and the other person does not. That might be something that you have to fight in court. If you believe the separate asset was transmuted or commingled, those are going to be also items that you would prove out in court. And so sometimes there could just be a few issues that you might have to take to court, which then you could determine whether you need to hire an attorney. So if you come up with a settlement offer, you start working together and it falls apart, you hire a mediator and it still falls apart, you could hire now an attorney, provide them with that settlement offer or disclosure, and that is the beginnings of the filing for your case. So now you've kind of eliminated a lot of the work that they have to do when they take your case, and you now have identified a few issues that need to be handled. So that's where they would come in. You can also file pro se or self-represented, and each state allows for this process. You'll just have to determine if you can file it through the electronic systems. Sometimes you will need a barcode or a lot of lawyers get basically a bar ID when they pass the bar. And so sometimes you need that to file all of the paperwork online. But you can go down to the courthouse in the court in your county and get all of the information and ask them how you can file and if you can do it online. There are other states that do not require an attorney to file through the system. And so this is where you have to do some of the work. A lot of times, each of the states will have resources online that are free. Okay. And, or you can also look at attorneys that could be, you have a fixed fee with them. What that means is you might have to pay one fee and they're going to file it and they're going to provide you with paperwork and you fill it out, or you give them your settlement offer that you've agreed to, which is now your settlement disclosure. They then input that into the system. The judge will then either agree or disagree to your settlement and then determine the next steps. A lot of times an attorney will also say whether the offer or the deal, the settlement is basically what they're making sure is that it's not super beneficial to one person and then detrimental to the other. So a lot of times, if you waive maintenance or you don't want, they tell you to waive maintenance and you'll get some other asset. For the most part, the judge is trying to make sure that the offer makes sense for all parties and is not beneficial to one party over the other. So you can also work through this mediation process and then bring in other parties. So if you need a business valuation, you bring in that person and they work with the mediator to determine the value and present it to the mediator and both of you together. A lot of times the value is the value, and there could be a slight range of value, but if you get two experts to come in, each of them could go high and low, and now you have an issue of splitting it in the middle. That's usually not the most beneficial way to work through the business valuation. Now, in this process, we're going to go through what a settlement training spreadsheet looks like and how you can walk through this process as somebody that is affiliated with valuation mediation, settlement process, or the Divorce Allies.